On Tuesday, state governors elected on the platform of the All Progressive Congress passed a vote of confidence on the Caretaker Extraordinary Convention Planning Committee of the party led by Yobe State Governor Bolanle Olugbani. By this action, the APC governor gave Buni and other members of the committee who had been embroiled in a legitimacy crisis a lifeline. The endorsement by the governors also paved way for the Caretaker Committee to proceed with the conduct of local government and state congresses, as well as the National Convention of the party. Now, joining us to explain why the endorsement by the governor was the best course of action for the APC is a lawyer, public affairs analyst, Bolanle Olugbani. Welcome to the show. Why is this the best action for the APC, owing to the fact that just this morning in the papers, Bolanle Buni, has started throwing those tantrums at people that are looking at that court judgment and saying, we have dissenting views in the APC. Somebody will have just thought that he'll let sleeping dogs lie. But this morning he went out attacking Festus Keyamo and other people that are speaking out in opposition.
Well, I think the acting chairman of the APC actually was, by his action and his comments, gloating over the lifeline that was given to his committee. Article 13.3 of the 2014 Constitution of the APC empowers the National Working Committee of the party, that is the executive with specific leaders and governors of the party, to set up a committee to perform any function based on terms and recommendations determined by that National Working Committee. And as such, that is the lifeline which Bolanle Buni has latched onto to remain in existence, to remain relevant, and to continue in his role as acting chairman. The Supreme Court of Nigeria, in the majority decision on the 28th of July 2021, per the decision of Emmanuel Agim, JSC, seemed to agree with the position that Bolanle Buni's tenure is temporary. It's not in contravention of Section 183 of the 1999 Constitution, and that Article 13.3 of the APC Constitution of 2014 actually empowers the National Working Committee to set up any committee to serve whatever purpose, and that gives Bolanle Buni that lifeline, that legal lifeline. To let sleeping dogs lie is not usually the character of politicians. Statesmen sometimes are the ones who allow sleeping dogs lie.
So you've stated what the judgment has said, but I want to get your own opinion. Do you agree with those who say this was a minority judgment and it remains as that, minority? It will not be referred to in law and should not be given credence to. Is that where you stand? And also, do you also think that what the APC has done by the power block of the governors is to give a political solution to a legal problem?
First of all, the Supreme Court is not a political solution finder. The Supreme Court acts in accordance with the law. The Supreme Court of Nigeria upholds the constitution of the country, which is indeed the supreme law, and any other law at state or local government level or any form of legislation that is in contradiction to the provisions of the Constitution is ab initio null and void. So the judgment of the minority Supreme Court judgment delivered by Eko Ejembi is a judgment of the Supreme Court, but it is not the judgment of the Supreme Court. It is not the majority judgment of the Supreme Court. When the Supreme Court is to make interpretation or pronouncements on constitutional provisions of the 1999 Constitution, the number of judges that sit is 7, and you can either have a 7-0 victory as a petitioner or appellant, or a 4-3 majority decision, while each justice of the Supreme Court has the power to write his own judgments. That is, you can have 7 written judgments. They may, as a matter of time saving and convenience, also adopt the position of one of their learned brother judges. And as such, when they concur in majority, that becomes a majority decision of the Supreme Court. So as at today, by law, the majority decision of the Supreme Court is the position of the Supreme Court on that matter. While other judges have their legal and constitutional right to dissent by giving a majority decision, by giving a minority decision, the majority decision is what stands. That is the point of reference. It is the judgment that can be referred to as a precedent in Nigerian case law.
Yeah, well, but the point that, I guess Adesua is saying is that, look, that minority ruling, remains at best academic in the circumstance, and that the majority position is what Buni and his advisors are standing by. But that's not really the question I wanted to ask. 2 things. 1, do you think that the APC faces the risk of internal implosion, particularly with congresses, that have been conducted, and local government elections and all the issues arising therefrom? And second, the Buni group is insisting that they are relying on the advice given by the Attorney General of the Federation. Yes, the Attorney General of the Federation is a member of the APC, but is he really in a position to offer legal advice to the APC when the party itself has a legal advisor, both past and present, who are, members of the party? Do you see some form of anomaly there, or it is in order for the Attorney General of the Federation, who is the chief legal officer of Nigeria, to become the legal advisor of APC at the same time?
I'll take your first question first. There's a potential for crisis in the APC if the hint is taken by dissenting members of the APC as regards to the content of the minority judgment of the Supreme Court. The court inter alia, that is the Supreme Court inter alia, stated that, and even in their majority decision, that the narrow jurisdiction of an election petition will not allow the Supreme Court to make a pronouncement on the validity or otherwise of whether the Mai Mala Buni-led committee is in contravention of Section 183 of the 1999 Constitution, which says that a governor cannot hold another position where he seeks to obtain or gets remuneration, or is by that position given double remuneration, both as governor and as a member of any other such engagement or employment. But in saying so, the Supreme Court also said in their majority decision that the Mai Mala Buni-led administration is acting in a temporary capacity, and in acting in a temporary capacity cannot be described as taking a double appointment or employment with double remuneration. That is the majority decision in one breath. And it also said that because of the narrow jurisdiction of the election petition, the issues concerning Section 183 of the 1999 Constitution as to whether Mai Mala Buni can hold 2 offices that give remuneration are best addressed by a competent suit before a court of competent jurisdiction, such as the High Court or Federal High Court, depending on the course of action. And it is pertinent, and it has been stated in the majority judgment, that Mai Mala Buni will be a necessary party in such a suit, where the opportunity to have him in the witness box, to have him cross-examined by those who have sued him, and for the court to hear the facts of the case so that they can reach a fair, they can give a fair hearing to Mai Mala Buni and reach a credible and proper determination of such issue by judgment. So that's the position of the Supreme Court. And if members who are still aggrieved take that hint, I think that there will be more litigation, which has the potential for party stability or party instability otherwise. And it may well, go as far as the Supreme Court on the issue of whether Maimala Buni, is having another appointment that gives remuneration. On the side of that, I want to say personally, and this is my humble opinion, that Maimala Buni, in such a suit, the definition of remuneration will be, heavily canvassed, heavily interpreted. At the present acting capacity of Maimala Buni, is he getting any form of sitting allowance? Is he getting any form of transport allowance? Is he getting a running cost to maintain the offices? Is he signing checks and paying salaries? Is he in any way being remunerated for the time spent as the acting national chairman? This interpretation of remuneration and the possibility of it being resolved either way will be one of the issues that will be resolved at a suit which members may potentially file within the APC. What regards to your second question, the Attorney General of the Federation is the #1 law officer of the Federation. He is the #1 lawyer of the executive arm, the federal executive arm of the federal government of Nigeria. Anybody who holds that office, because of the nature of the office, is expected to be non-partisan. His pronouncements as per party politics, party administration, and indeed public legal advice as to political decisions that are taken by his party, which of course will impact on the government which he is a member of, should not be so publicized, because it will be an issue of ethics, morality, professionalism, and the need to ensure that the position of the Honorable Attorney General and Minister of Justice is not tainted by any form of partisan perception by the ordinary man on the street. So I would think that Abubakar Malami ought to know that positions expressed as legal advice to the APC and the National Executive Committee of the APC, and indeed the National Working Committee, is a usurpation of the functions of the National Legal Advisor of the APC. Simple as that.
Right. We'll go on a quick break. We'll come back and we'll talk to you more after this commercial break. Stay with us. We'll be right back. Welcome back to the Morning Show right on the Rise News channel. We still have lawyer, public affairs analyst Bolanle Olugbani, and has been talking to us about all that is going on with the APC. A lot of people are already challenging even the legitimacy of Maimala Buni, and that showed in this last World Congresses. Is it a safe choice for him to still carry a hand and be the one in charge of the convention? Wouldn't it open an array of court cases, owing to the fact that when you look at the antecedents of the APC, we all know what happened, even with the emergence of Maimala Buni to calm the storm. We all know that fight that went on with Adams Oshiomhole. At some point, we thought it was going to be Governor Jimobi leading the party, and we all know how that went on. And there's a faction of the party strongly opposed to him and fighting so hard. Isn't it time to look at this critically?
Well, there's a very strong possibility that the legitimacy issue of the Maimala Buni-led committee is still a huge sticking point in the way and manner the APC and the members of the APC see themselves. The Supreme Court, in the recent decision of Jegede and another versus INEC and others, has also restated the earlier position of law, the case law position on challenging primaries, challenging actions of the executive of the party, and has restated that it's only those who are aspirants to elective positions at the ward, state, and local government level. Those are the ones who have the legal right or local standard, to bring a suit to challenge the actions of whichever executive they intend or wish to challenge. So, depending on whether the interest of the politician at ward, state, or federal level is coterminous or aligned with, the interests of the dominant group, you could see a flurry and a floodgates probably of legal challenges, starting from now. And it has the potential also, if I may say, of destabilizing the focus and concentration of governance, because instability in the ruling party has an impact on the Muhammadu Buhari-led administration. Because if the party has a crisis, attention, time, money, and energy will be, deployed to resolve such crisis. Governance suffers, and the people of the country whose security and welfare is the primary purpose of government will not be better off for it.
I just wanted to make a clarification, because in your earlier submission, you were talking about the validity of this committee being led by a serving governor. I wanted to ask you, are you saying that the chairmanship of a political party is not an executive position? If so, then what is an executive position out of the statutory position as a serving governor? What will constitute an executive position?
Well, the provision of Section 183 of the Constitution clearly states that a serving governor cannot hold another office where he gets remuneration. The Supreme Court, in this decision of the 28th of July 2021, Jegede and another versus INEC and others, stated in their own wisdom, in their majority decision, that Buni'S Buni's tenure is one that is temporary. It stated also that the issue of remuneration for Buni'S Buni cannot be addressed as to whether he is in contravention of Section 183 of the Constitution, because of the limited jurisdiction which an election petition allows to address certain issues in that petition. So that the only way where we can discover or find out by judicial process whether Buni'S Buni is holding two positions in contravention of Section 183 of the Constitution is to have that matter litigated at a high court or competent jurisdiction. So that is the position as per the Supreme Court as of today. So if the high court is, if a suit is instituted at the high court or competent jurisdiction, whether federal high court or state high court, depending on the course of action, we will get a determination of that issue, which may of course be appealed right up to the Supreme Court, and that will enrich the history of our case law, and that will be an established position with regards to this type of novel decision. But from a commonsensical point of view, it would appear that while the Constitution, Article 13.3 of the APC Constitution, allows the National Working Committee to establish a committee for any purpose, and it is under that provision that it appears that Buni'S Buni's Caretaker Committee, has been established. It, in my own humble legal opinion, runs counter to the constitution of the APC, because I would have thought that when a National Executive Council is dissolved, it ought to have been dissolved by proper means. And if it is dissolved by proper means, the next logical thing to do is to arrange for a national convention to replace officers who have been removed from their positions. An acting national chairman acting in the capacity of this type of arrangement, has created a problem which final outcome no one can easily determine at this stage.
Just about a minute or two to go, but very quickly. After the 2019 general elections, the review process initiated by the Independent National Electoral Commission, one of the outcomes of that process was the emphasis on the need for political parties to focus more on internal party democracy. And here we are, the two major political parties have been having one form of crisis or the other. Will you say that these political parties have refused to learn from the lessons of the past? And what do you think is the implication for the integrity of our democratic process, the political party system being at the heart of it?
Well, I think my humble opinion of that question is that as with the Constitution of Nigeria itself, the 1999 Constitution of Nigeria itself, the operators of whether the party constitution or the Nigerian Constitution itself have refused to imbibe the spirit of the Constitution. What you find that obtains in the two major political parties is a system where everything is, where everything appears to be choreographed, where everything is stage managed, where you don't even actually have primaries. It's one intrigue, out-maneuvering, or the other that obtains in both parties, thereby making internal cohesion of the parties, internal democracy, being pushed to the background. There's a track record of impositions and a track record of, observance of the constitution of both parties more in the breach than in the actual positive observance. So for our country, it doesn't signpost a very, very comfortable future. We must learn to practice this democracy, the way it ought to be practiced, as provided for expressly by the constitutions of both parties and indeed the 1999 Constitution. But I believe that one of the greatest omissions in the present Constitution of the present 1999 Constitution is the omission of independent candidature. If the political parties are not observing or complying with their constitutions, if there was a provision in the 1999 Constitution that says that without you being nominated or sponsored by a political party, if you meet certain criteria, you can contest for any elective office in this country, I think that would have reduced and given alternative options to individuals who have a positive agenda, a progressive agenda for the country, to be able to explain their manifesto and go directly to the people of this country to ask for their votes. But the way it is now, if you are not nominated and sponsored by a political party, then you cannot contest for any position, elective position in this country. And that is why it appears that the internal administration and internal organization of the parties is subject to such heavy pressure of manipulation, of godfatherism, of intrigues, and all manner of potential crisis.
Well, thank you very much, Mr. Olugbani, for joining us on the morning show. Thank you very much indeed for your time and insights.